Welcome class. In this module, we are going to explore a very interesting facet of IP protection, which is the neighboring rights protection. So traditionally, there was a close identification of copyright protection with the individual creator, the romantic notion of the author. The romantic notion of the author led to copyright protection in traditional context for artistic, literary, musical, and dramatic works. It was felt, and I'm talking here about the time when the Berne Convention was uh, thought of, conceptualized. It was felt at that point that works which involved creative effort but was the product of a team work was not necessarily fitting well within the purview of copyright protection. So the traditional notion of the romantic author did not, to a large extent, gel with the way some of these works such as phonograms, for instance, even performances, broadcasting rights, the way these works were created did not gel with the idea of the romantic author. These works were largely the product of team effort. And it is for this reason that you do not find mention of these works in the Berne Convention, the most important and pioneering effort in the field of copyright law as far as international treaties go. In this module, we are going to explore the nuances of protection of performances and broadcasting rights. These are considered the neighboring rights in the Indian copyright law framework. We do not look at phonograms here because sound recordings are covered within traditional copyright protection in India, and they are a category of works expressly mentioned in the Copyright Act post 1983. That is when the act was amended the first time, and sound recordings were recognized as an express category of works entitled to copyright protection. But as far as neighboring rights are concerned, the two categories of such rights in Indian law are broadcasting rights and performance rights. And these are the ones we are going to explore in the course of this lecture. Coming back to the international framework, because this framework is important to understand where globally India stands in terms of recognition of neighboring rights. As I already mentioned, the Berne Convention did not recognize these categories of rights or categories of works for protection under copyright. It took some time, a fair bit of time in fact, before the first treaty internationally to recognize protection for phonograms, performances, and broadcasters came about, and this was the Rome Convention in 1961. The Rome Convention took a minimalist view of protection for these neighboring rights, but indeed it granted protection. When saying that they granted or envisaged a minimalist protection, all that I mean to say here is that it was much narrower than the extent of protection as we see today in Indian law, or even as recognized by international treaties that came about later. So what exactly did the Rome Convention do? The first thing it did was to define a performer. Article 3A of the Rome Convention defined a performer as an actor, singer, musician, dancer, or any other person who acted, sang, delivered, declaimed, played in, or otherwise performed a literary or artistic work. Now, once you are recognized as a performer, or you qualified as a performer, and you created a performance, what was the scope of protection? For this, we have to turn to Article 7 of the Rome Convention. There are three broad rights conferred by Article 7 on the performance or on the performer in respect of that performance. These rights were: 1. The right against the unauthorized fixation of the performance; 2. The right against any unauthorized reproduction of any authorized fixation; and 3. The right against the communication to the public of such performance in an unauthorized fashion. So in all these cases, that is whether it was communication of the performance to the public, fixation of that performance in any particular medium, or reproduction of an already fixated performance, permission had to be taken from the performer, because the exclusive right vested in respect of any of these acts with the performer. However, and this is what makes the protection a minimalist one, as I had already mentioned before, there was a huge restriction on the scope of this right. This restriction arose in turn by way of Article 19 of the Rome Convention, which provided that once the performer had consented to the incorporation of that performance as part of a cinematograph film, he could no longer claim in respect of that performance any of the rights mentioned in Article 7. That's the rights that we have already discussed, three important rights of subsequent reproduction, fixation, or communication to the public. So from this position in the Rome Convention, one could surmise that the idea was not so much to grant absolute autonomy to the performer in respect of any use of that performance, but a conceptualization of the performance right as a form of monetization right. So the performer could make some money out of the performance by refusing to consent with the incorporation of that performance and exercising any of the rights, or getting some revenue out of consenting to the incorporation of that performance. But once he made that money, he could no longer say that the person who had incorporated it in the film could not reproduce it or could not communicate it to the public. So this was in a sense a binary on-off kind of situation, where either you consent to the incorporation and you lose your rights, or you exercise your rights but without consenting to that incorporation as part of a film. The moment you consented to the incorporation as part of a film, then the person who owned the rights in respect of that film would get to decide whether the performance must be reproduced, how many times, to which audience, and so on and so forth. This minimalist view of performance rights, however, came to an end in 1996 when the WIPO Convention on Protection of Phonograms and Performances, the WIPO Treaty on Protection of Phonograms and Performances, came into effect. Apart from extending the scope of performance rights duration to 50 years, this treaty did away with the minimalist conception wherein once you had consented to the incorporation of the cinematograph of the performance as part of a visual or audio-visual work, you would lose any further control over how that particular performance could be put to use. Doing away with that, the treaty provided for various important rights, such as the exclusive right of distribution to the public of the original and copies of the performances fixed in phonograms through sale or any other transfer of ownership or through commercial rental, and the right to a single equitable remuneration along with the producer of the phonogram for the direct or indirect use of phonogram of the performances which were published for commercial purposes, for broadcasting, or for any communication to the public. In other words, the treaty clearly thus does away with the fact that once it is consented for incorporation as part of a visual or audio-visual work, the performer would no longer have any further rights, and provides for a distribution of royalty between the performer and the producer of the phonogram itself. In addition, the treaty also recognized moral rights protection. The two important rights of integrity and paternity were carved out and conferred to the performer. Therefore, the performer could now insist, one, that he would be given the credit for any performance made by him, and two, that no such performance would be distorted or mutilated in a manner that affected the credibility of the performer or caused injury to his reputation. Acknowledging the growth of digital media and the power of technology to protect works, the treaty also allows the performer to resort to self-help measures such as technological protection measures and electronic rights management information, and performers can employ these in order to prevent the infringement of their rights. The treaty is also not entirely maximalist in the sense that it has allowed member countries to extend any fair use limitations that they would have already got in respect of the exercise of copyright to the exercise of performers' rights as well. Nothing new has been added to this framework by the TRIPS, though of course the WPPT in fact comes post TRIPS, but the TRIPS does not in any case add anything much to the Rome Convention, so it is something that one need not really look into much if examining performers' rights and its scope. So currently the position internationally is simply this, that if you consent to the incorporation of your performance in a film, you still have rights in respect of your performance insofar as reproduction of that fixation is concerned, insofar as communication is concerned, and you definitely have an equitable right to receive royalty, even if not a right to block the owner of the phonogram from making these important decisions on subsequent use of that phonogram which incorporates the performance. Having mapped out the international position relating to protection of performances, we can now turn to the Indian law and the provisions in the Copyright Act which deal with performers' rights. To start with, let's go to the definition of a performer in section 2QQ of the Act. The definition includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. Now, a performance is defined as any visual or acoustic presentation made live by one or more performers. In 2012, the Copyright Act was amended, and the definition of performer was also amended by way of insertion of a proviso. The proviso reads as follows: provided that in a cinematograph film, a person whose performance is casual or incidental in nature and in the normal course of the practice of the industry is not acknowledged anywhere, including in the credits of the film, shall not be treated as a performer except for the purpose of clause B of section 38B. That provision is not of much concern for the moment, as it deals with the moral rights of the performer. The insertion of this proviso has raised some very interesting and important questions relating to the scope of performers' rights, especially from the perspective of who a real performer is. The main controversy is relating to the rights enjoyed by one, film actors, and two, people who sing, the playback singers in movies. Now, one argument is that a performance has to eventually be one that is made live, and that neither film actors nor playback singers are performing in live. But the one judicial opinion that we currently have on this issue, which of course is not directly on the point, because this was a case that could be and indeed was ultimately decided on a separate legal argument. This is Neha Bhasin's case. In Neha Bhasin's case, the Delhi High Court has made a few stray observations to the effect that a performance which is made in a studio is also a live performance. Now, if a performance that is made in a studio is a live performance, it has serious implications for the scope of royalty sharing in the entertainment industry. And the reason for this is because the 2012 amendment not only does insert a proviso to the definition of performer, the one that we have seen thus far, but it also expands the scope of the performer's rights. And how does it do so? To do this, let's just go to a brief historical survey of how performers' rights came about in India. Performers' rights were introduced in the Indian legislation in 1996 by way of an amendment. So the 96 edition of performers' rights conceptualized the scope of these rights as being similar to what we saw with the Rome Convention. Therefore, if the performer had consented to his incorporation of the performance as part of a cinematograph film, then the performer lost all subsequent rights in respect of reproduction and communication of that performance to the public. However, the 2012 amendment has changed this position. The 2012 amendment clearly delineates the various rights enjoyed by the performer, and it provides for the payment of royalties in case of making of the performances for commercial use. And this right is, in my opinion, akin to the equitable remuneration right introduced by the WPPT, that is the WIPO Treaty on Protection of Phonograms and Performances. So where does this take us? It takes us to a situation where, if we were to concede that a film actor or a playback singer were performers for the purpose of this enactment, then even if they were to consent to the incorporation of their performances respectively as part of a cinematograph film, they would be entitled to royalties for any use of that cinematograph film other than by way of enjoyment by the producer of the film of the performer's right in the same film. Therefore, for any subsequent use made by the producer of the film of that particular performance, he would still have to share royalties with the performer. And indeed, this has been made a sort of non-waivable right. So the position as it currently stands is such that the performer can make a choice. He can either choose not to incorporate his performance as part of a film or to go ahead and do so. If he does not incorporate the performance, then he continues to enjoy all the rights in respect of that performance, including the right to make a sound or visual recording of the performance and reproductions and broadcasts of the performance. If on the other hand, he were to permit the producer of a cinematograph film to incorporate it, then the producer shall enjoy the rights of the performer in respect of that film. But in any case, the performer shall be entitled for royalties in case of performances being used for commercial use, and more importantly, the performer does not lose his performance right in respect of other films or in respect of broadcast of that performance, or even in a situation where the producer of the earlier film were to modify the performance and use it, or were to modify the film and incorporate the same performance in that modified film. So in all these respects, the performer would continue to exercise his performance rights, and this really goes to further uses of the cinematograph film, such as, for instance, remake of the film, even the translation of that film, or the dubbing as one would popularly know it, of the film in a different language, and so on and so forth. So if the performer's definition extends to studio actors and playback singers, then there is a clear difficulty in delineating and contracting of rights insofar as the actual cinematograph film itself is concerned. Currently, we do not have a conclusive answer from the judiciary because the matter has yet not gone to court for adjudication, and the amendment is a relatively new one. Now, leaving the matter of scope of rights of the performer in strict copyright terms aside, Section 38B, which was also introduced in the 2012 amendment, provides for moral rights akin to what we saw with the WPPT in respect of the performance. So the performer again here has the right to paternity and the right of integrity of performance. So moral rights are provided. Again, the duration of performance rights is being extended by the 2012 amendment from 25 to 50 years. So in fair measure, there has been an expansion of performers' rights in the 2012 amendment. Now, how do these rights come into conflict with, or the interplay between these rights and the copyright in respect of cinematograph, film and sound recordings? This is a matter that we will take up soon, but after discussing broadcasting rights. Broadcasting rights, or broadcast reproduction rights as they are better known in India, were internationally recognized again for the first time in the Rome Convention in 1961. So the whole purpose behind these rights, as initially conceptualized at least, was to grant a limited right to commercial entities engaged in the business of broadcasting in respect of their signals. The idea was in fact to give them an independent right to sue. The reason is evident once we think of the kind of content that broadcasters deal with. It is content for which, in respect of which copyright would be with various different entities. So what happens when a pirate captures the signals of the broadcaster and airs the different programs which are relayed by the broadcaster on its private channel? Is it technically or practically feasible to expect each of these copyright owners of these various different programs relayed on the broadcast station to get together and sue the pirate? Due to the practical difficulty of this, and considering that the broadcast by itself, along with the advertisements and different contributions made by the broadcaster, including the sequencing of the different programs and so on and so forth, had independent value, it was thought fit to recognize rights of reproduction over the broadcast and rebroadcasting of already broadcast programs. So let us quickly see the scope of rights as envisaged by the Rome Convention before we proceed to discuss the law in India on broadcast reproduction. Article 3F of the Rome Convention defined broadcasting as the transmission by wireless means for public reception of sounds or of images and sounds. Rebroadcasting was defined as the simultaneous broadcast by one broadcasting organization of another's broadcast. The minimum rights of broadcasting organizations were the authorizing or prohibition of A. the rebroadcasting of their broadcasts, B. fixation, C. reproduction of such fixations, and D. the communication to public of the broadcast. 20 years was the duration of the broadcast right, and this was computed from the end of the year in which the performance or the broadcast took place. Article 15 of the convention also provided that broadcast reproduction rights could be made inapplicable to instances of private use, use of excerpts in connection with reporting, ephemeral fixation by broadcasting organizations, that is the temporary fixation for the purpose of its own broadcast, and sole use for purposes of teaching or scientific research. There is no WIPO treaty yet on broadcasting, and therefore the international position has almost come to a standstill with the Rome Convention, though there have been attempts to come out with the WIPO treaty. Nothing on the ground yet. So with this, we should proceed to the Indian law on broadcast reproduction. Interestingly, India's protection for broadcasting organizations came in 4 years prior to the Rome Convention, that is in 1957, with the original enactment. India started protecting broadcasting signals. Of course, at that point in time, there were no various broadcasting organizations, and all that we really had was the state broadcaster, that is Doordarshan. However, protection was existent and it was granted to the signals which were transmitted by Doordarshan. Interestingly, the term broadcast was not present, and instead the expression radio diffusion was used, and the definition of this expression included communication to the public by any means of wireless diffusion, which again is a throwback to, as we see, the Rome Convention, though the Rome Convention came later, as already mentioned. So it is pretty similar to the Rome Convention. Though wireless diffusion did look a bit restrictive, later this has been expanded, and currently the definition includes both wireless and other forms of diffusion. The interesting point is that there was a special right in all situations where a program was broadcast by radio diffusion by the government. The duration of this right was 25 years, and it extended to restraining rebroadcasts of the program, communication of the same to the public, and recordings of the broadcast. The term broadcast was expressly included in the Act in 1983, and broadcasting organizations were recognized post the liberalization of India and opening up of the private sector in the broadcasting industry. And this happened in 94. So effectively from 96 we had broadcast reproduction rights as the Act currently understands them in the context of applicability to private broadcasting organizations. There are no major changes to the scope of the right or its duration in the 2012 amendment. Therefore, one could say that it's broadly the 96 position that survives in the case of broadcast reproduction rights. Now, what is the scope of the broadcast reproduction right? A very interesting situation arose in ambient space sellers, where the pirate was using the broadcast signals and modifying the same. The pirate was blanking out the advertisements in the earlier, that is the original broadcast, and replacing it with its own advertisements. Now, this is in a sense not what the broadcast reproduction right was primarily meant to address. The idea was to stop rebroadcasters from free riding. So the whole purpose of the right is, in a strong sense, to prevent free riding and unjust competition or unfair competition. At the same time, the court in this particular case felt that one of the major sources of revenue for the broadcaster is what it gets from the advertisement. If the advertisements which are part of the broadcast are not protected as they are, and instead a rebroadcaster can just black out these advertisements, even if authorized to transmit the broadcasts, that would be a huge drain on the revenue. So in some sense, the court recognizes broadcast reproduction right as a broad revenue right rather than a narrow unfair competition right in the Indian context, as one can surmise from the decision in ambient space sellers. And this is also evident from the more recent decision in Delhi TV versus ICC, because here too one of the major issues was as to the scope of the broadcast reproduction right. The program which is used by ICC, which is owned by ICC, and for which there are official broadcasters, clippings from that program were used to run commercial programs, and the court categorically held that when it comes to reporting of news, it is fine and one could go ahead and use footages from the event. But when it comes to commercial programs which have their own advertising slots, then there is a fundamental problem because it infringes on the broadcast reproduction right. Again, the philosophy seems here to not entirely worry much with the unfair competition, because here again there is no unfair competition in the strict sense, because the rebroadcaster is not broadcasting the program as it came on ICC's official broadcasters channel. Rather, it is using different footages from the program and coming up with its own program with its own anchor and people in the studio who discuss different aspects of the game and so on and so forth. So it added a lot of value, and in that sense there is no free riding. It is only use of the particular clipping to transform and create a new sort of work. In strict sense, that could even qualify as a transformative work for fair use purposes. Still, the court felt that it violates the broadcast reproduction right because the broadcast is used, or at least parts of the broadcast are used. One will have to see how this plays out in the future and whether the fair use exception applies only in a non-commercial setting, or whether it is possible still to envisage the use of the existing broadcast in a commercial setting, as long as there is a transformative use. And a transformative commercial use, whether it would be coming within the purview of fair use or not, is something on which the law is still unclear, and Delhi TV cannot be considered a conclusive judgment on that point. It is also worth mentioning at this juncture that a lot of broadcast reproduction right enforcement today is through usage of John Doe orders. So at the time that a particular event of public interest, such as for instance the FIFA World Cup that happened this year, if there is a strong likelihood of widespread piracy during such events, the court is open to granting John Doe orders, appointing advocate commissioners who can go and search and seize equipment that is used by pirates to capture signals and thereby prevent piracy from occurring. So this is the normal method by which broadcast reproduction rights are being enforced currently. The last leg of our discussion today has to focus inevitably on a very important provision which was introduced in 2012 and which clarifies the scope of neighboring rights in general. This is section 39A. There are two important provisos here, and the scope of this shall be touched upon briefly. The first proviso here says that when the copyright or performance right subsists in respect of any work or performance that has been broadcast, no license to reproduce the broadcast shall be given without the consent of the owner of the right or performer. The second proviso says that the broadcast reproduction right or the performance right shall not subsist in any broadcast or performance if it were to be an infringement of the copyright in any work. And the third important aspect of this provision is that it says that the broadcast reproduction right or performance right shall not affect the separate copyright in any work in respect of which the broadcast or the performance has been made. So the simple question here is, if there is an underlying copyright in respect of a particular work, and then the work is incorporated as part of a cinematograph film, and then the cinematograph film itself is sought to be broadcast, how does the allocation of royalties and how does the transfer of rights have to take place effectively? Because the provision, as we see, says that there is a separate copyright in respect of the work and there is also a separate broadcast reproduction right or performance right. So what happens to the separate copyright and how can that be enforced? The first important point of distinction here is between a copyrighted work and a performance, and the second point of distinction is between a live performance and one that has been captured on a particular medium and is subsequently broadcast. As far as copyrighted works themselves are concerned, the law is now pretty clear post the decision of the Supreme Court in Eastern India Motion Pictures Association, and then two very recent decisions, one by the Delhi High Court and the other by the Bombay High Court. And these decisions effectively say that the copyright in the musical or the literary work is separate from the copyright in the sound recording or the cinematograph film. So once the musical or literary work has been incorporated as part of a sound recording or a cinematograph film, then all further use of the sound recording or the cinematograph film as they exist are to be done pursuant to a license which is lawfully obtained by the owner of the copyright in any of these works, and not the owners of the copyright in the literary or the musical works. In other words, there is no further right that the owner of the copyright in the literary or musical work has in respect of usage of the cinematograph film or the sound recording, as the case may be. Now coming to the second point of distinction between live performances and performances that are recorded or fixed on a medium and then broadcast. As far as live performances are concerned, the fact that there is an authorization to broadcast that particular performance will not kill the separate copyright even in respect of recordings of that broadcast. So, for any use of that particular broadcast in any manner, there has to be an authorization taken from the owner of the copyright. So no license to reproduce the broadcast shall be given without the consent of the owner of the right or the performer. On the other hand, in the case of works that are recorded, that are fixed on a cinematograph film, the law then has to finally favor the owner of the right in the cinematograph film over the owner of the right in the musical work, underlying literary work, or the underlying performance, as it currently stands, for the simple reason that Eastern India Motion Pictures seems to indicate that the separate copyright will only be in respect of separate use of that work and not in respect of use of the cinematograph film or the sound recording, as the case may be. And this is borne out, as I mentioned earlier, by the subsequent decisions of the Delhi and the Bombay High Court as well. So currently the position seems to be this, but again there is no conclusive verdict by any of the courts on these provisions, that is on section 39A. So we will have to wait and see. So with this we come to an interesting to the end of an interesting discussion on neighboring rights protection, and we kind of can conclude that India's protection is as good, or probably in some respect even better, than what exists currently internationally in respect of protection of these rights of performers and broadcasters. Thank you.